I'll talk a bit about the softer issues after we kind of defined what we're discussing. And fraud, when you talk of fraud, everybody assumes they understand it really well. It's kind of a very intuitive concept to human beings. What is fraud? What is, so at its most basic, fraud is misrepresentation. And it's not simple misrepresentation, it's misrepresentation if somebody relies on that misrepresentation and harms themselves in that process. If you just lie, that's really not considered fraud in law. So we'll talk about ingredients a little bit, so that we are on the same page in terms of the definition, and then we'll talk of softer issues, because securities market or financial market fraud has diverged somewhat from the classic definition of fraud, when you're trying to sell a horse which is unwell and the person bought it thinking it was a horse in good shape, to an anonymous order matching system in which you don't know who the buyer is, and therefore the basic concept of contract law does not really apply. You really can't sue a person you've never met, who you have no interaction with, who you don't know who you paid that money to, because there's a stock exchange in the middle. So in this market, which is continuously progressing, it's moving every microsecond, every 6 microseconds. The basic concept changes somewhat, and we'll look at the ingredients, see which concepts have needed adaptation. And the most interesting thing is you have contractual law, which sounds fairly straightforward, that you sell somebody a product, you misrepresent, you say this is X, but it's actually Y. And therefore, the counterparty sues you, saying that you told me it's X, but it's in fact Y, so give me the difference between X and Y, or take X back. But it's also the most rigid in an anonymous order matching system. And what has really saved the day is really the concept of fraud. Also, as we lawyers like using jargon, the tort of deceit, which is the same thing as fraud. But it's basically a judge-made law. There's no law, there's no statute book which defines common law fraud. And that's actually been the one which has been the most adaptable. It's a 400-year-old law made by hundreds, maybe tens of thousands of judges, really. And because it's constantly evolving, is the one law which applies most beautifully and most wonderfully to modern securities markets, and we'll talk a bit about that. So I'm planning not to exceed 20 or 25 minutes, so that we can talk about specific issues. So before we start, I think just to get a sense of what securities regulation is, essentially just two things. You can boil it down to two things. One is the law of disclosures, which is you need to disclose A, B, C. If you're a listed company, this is what you need to disclose. If you're an intermediary, this is what you need to talk about. And the other is fraud, and these two are connected concepts, because as I said, fraud is nothing but misrepresentation. If you don't make if you lie, for instance, or if when the law obliges you to speak and you keep quiet, so even silence can amount to fraud. So the disclosure and fraud are the key kind of elements of securities law, and pretty much everything else surrounds these two concepts in modern securities law. It was not always so. Before 1988, we had a merit based system in which you had a babu who used to decide whether a public issue can happen, at what price it can happen. Pretty much every granular detail of an IPO was decided by a babu sitting in the Ministry of Finance. So we've of course come a long way from there. Now we rely on the wisdom of the crowds really to determine whether the issue is good enough, and we have lots of court rulings, in fact, which support this. So people file PILs and people file cases in courts, and courts have systematically said that even if there's some kind of jugglery in the disclosure documents, in the IPO documents, we're not really, I mean, you figured out that the so-called fraud is there in the IPO document itself, so you're sensible enough to figure it out. So in fact, there are two wonderful Supreme Court rulings which say something to that effect, and which shows that we've come a long way in understanding. the basic difference in pre 1988 and post 1988. Earlier we tried to remove stupidity from the market, now we try to remove ignorance from the market. And if you just think about it, they are very, very different concepts. Trying to be a nanny state and prevent investors from making wrong choices versus making sure right information comes to the investors. And if there's any wrong information which comes to investors, you get prosecuted for fraud. So that's the kind of modern concept versus the pre 1988 concept. The Greeks used to say that mask was in fact not a mode of hiding, it was a mode of disclosure. In current securities market practices is the other way around. People bury information in hundreds of pages of disclosures, and therefore they kind of sometimes get around by hiding a fact in a footnote, and then if somebody goes against them, they say, yeah, look at page 488, it's there on the third footnote. So, but nonetheless, we really come a long way. So, we will just start with one of the most famous fraudsters. He is not the biggest fraudster of all times, but he is one of the most famous, and his name is Charles Ponzi, and at the peak of his career there was a queue 4 kilometers long, people wanting to hand over their life savings to him. He was of course caught and went to jail. He learned law in jail, jumped bail, then went to Florida, where he sold underwater land sight unseen, $4 an acre, where again he was caught, and obviously communication was not so good those days. So, courts in Boston didn't know about his prosecution here. Ultimately, he was deported in the year 1934, which is also the year in which the SEC was formed, and to Italy. He was an Italian immigrant. And interestingly, his company, which started in 1990, was called the Securities Exchange Company. I'm not making it up. While we talk of frauds, we also must talk a bit, maybe in the discussion we'll talk about mass hysteria. And I think 17th century Holland is a classic example of tulip mania. There's a story about, I mean, you just couldn't go wrong with investments in tulips. Banks would take one tulip bulb as collateral for buying a house, for buying a ship. One sailor mistakenly did not lock the most, this is the most prized tulip of that time, Semper Octavius, named after a Roman emperor. And it actually cost more than the entire ship. And one of the persons in the ship thought it was an onion, so he picked it up and ate it up. He went to jail for 6 months for that. So, just kind of to give you an overview, you have contractual fraud, try to sell a unicorn and it's actually a horse. The tort of deceit, which I mentioned, is the most appropriate because the most protean is the most changes form most easily because it's judge made law. There is statutory law, which is Companies Act, SEBI regulations, they all define fraud. If you cross this line, this is the consequence you will face, and we will talk of consequences. And finally, criminal fraud, which is again contained in the same statute, but the consequences are more harsh. You go to jail if you cross the criminal line. Couple of examples of fraud, and I've deliberately not put insider trading here because its destiny has diverged from the classic definition of fraud over the past 15-20 years. The most classic type of fraud is misrepresentation. You put a wrong information in an IPO document, you lie about the quarterly earnings of a company, etc. Churning is when brokers continuously buy and sell securities to earn commissions for themselves, and rather than discharging their fiduciary duty to the investors. Front running is again when somebody runs ahead of the client's order and places an order before the clients, which again amounts to fraud. Manipulation is either price manipulation or volume manipulation. You create appearances of a price which is really diverging away from value. And recommendation contrary to interest, which is also known as suitability. It's a kind of a more recent definition or type of fraud, typically selling kind of high risk products to widows and orphans, as they call it. So, these are just 4 or 5 types of financial securities frauds. I mentioned common law fraud, and this in the US it's also known as, it's drafted into a rule called, very famously, Rule 10b-5 of Securities Exchange Act. And really this is the period post Charles Ponzi, post all the other frauds which occurred in the 1920s, which of course forced the then president of the US to pass all these laws. And there's a kind of a Cambrian explosion of laws, securities laws, antitrust laws, lots of other major pieces of legislation which we still rely on today in their jurisprudence, evolved really in the 1930s and maybe early 1940s. And this is nothing but a redrafting of the common law principle against fraud, and we'll look at what that really means. The consequences of both Rule 10b-5 and the Indian equivalent, which we call FUTP, lawyers love jargons, fraudulent and unfair trade practices regulation of SEBI. Consequences are typically administrative, which means SEBI takes action as opposed to going to court, which is a civil action, or a penal action, which is can be a penalty or can be going to jail. So, here are the ingredients, and again, as I said, most people think they understand fraud, but it's very useful to break it up into its ingredient parts to understand it, the beast a lot better. The first is mens rea or intention, and that's critical, and even some regulators get in the trap of ignoring it, which is there has to be an intention to defraud. Negligence can never amount to fraud. Okay. And that's where when we talk of insider trading, I'll talk about it, where we've diverged further and further away from the concept of mens rea or intention involved in a fraud. But it's a critical aspect of fraud, because fraud is not simply a civil offense. It's quasi criminal, and therefore the standard of proof, as we call it, is much higher. The burden of proof is much higher. Similarly, charging somebody for fraud would also entail a higher level of evidence. The second is, of course, misrepresentation. So, it can either be lying, which is classic misrepresentation, or it can be omission. If there is a duty to speak and you do not speak, if you keep quiet, you have committed. Third is materiality, which is pretty commonsensical, which is, it has to be a material offense. If you simply lie about your age in a prospectus, that's typically not material, but if you lied about your age because you wanted pension benefits for yourself, it becomes material. So, it depends on the facts of each case, and they use what is known as the probability magnitude test, which is kind of self-explanatory. The least intuitive is actually reliance and loss causation, and reliance is essentially you have to rely on the fraud. So, you have to show that you actually read the entire 500-page prospectus, you saw that third footnote on page 488, and you bought the securities knowing that, and then obviously that's not practical at all, right? How do you prove that you, even if you have read that prospectus, how do you prove it? Did you record your reading it? So, in the securities market, they introduced a shortcut known as fraud on the markets theory, which essentially means it's a presumption. Presumption is a legal shortcut, essentially, which says we'll presume that you have read the prospectus, and it's the company which has to say that you have not read the prospectus, because again, this is where the adaptation has come. In a classic unwell horse, you could prove very quickly, very easily. In a modern securities market, you can't really prove reliance. So, the law has changed this concept. So, you still require reliance, but there is a presumption that you relied on the fraud or fraudulent representation. And loss causation is also a little less intuitive, which is the loss has to come from that particular fraud. So, there is another very classic case in which somebody borrowed money from a bank and they invested in securities, in very risky securities, and they are able to show that the bank should not have lent them money, because the securities they posed as collateral were not acceptable securities. So, they sued the bank for the loss they suffered in their portfolio, and the court said no loss causation, mainly because that is a but for causation, which is, had they not lent me the money, I would not have made the unwise decision, but that is not good enough. The loss has to come from the fraud, and here the loss was not arising from the fraud, the loss was arising from the poor investment made by the investor on its own. And the final is, of course, in connection with purchase or sale of securities. So, that's all. That's the presentation. Now, I just want to take you through. I'll spend 5 or 7 minutes more, particularly taking you through couple of concepts of insider trading. Now, insider trading actually evolved in the 1940s in the US. It did not exist anywhere in the world. It's actually a very recent phenomena for most of the world. Till the 1990s, Japan did not have a law against insider trading. We introduced one law as well, relatively recently. So, it's a new beast. And in the 1940s, they the American regulator discovered one particular case in which they saw a person trading, basically a printer who was passing on, misusing the information which they were getting in a kind of M&A situation. And they said, there's a section in the act, but there's no rule, and the section said that as per the rule. So, then and there they drafted the rule, which is now known as Rule 10b-5, and based on that they went after this person. And essentially it comes, if you look at the ingredients of fraud, insider trading actually fulfills each one of them. So, it requires mens rea, it requires misrepresentation. Okay, let me come to that in a second. Why misrepresentation? There has to be materiality. So, price has to move. If the price sensitive information hits the market and the price moves, then it becomes material. Again, easy to assess. There has to be reliance and causation, because it has to be because of the insider trade that the price moved really. The critical thing which is slightly different is misrepresentation. Now, insider trading, the law of misrepresentation came out of a fiduciary obligation of the directors or top insiders, top management of a company, to put the interests of the company before their own interests. So, really the origin of insider trading arises out of this definition, with the caveat that a person has a fiduciary duty to his or her company. So, every time they use information of a company, belonging to a company, to their own advantage by trading the stock, they are violating the fiduciary duty and therefore committing fraud. So, that is kind of the classic definition till, yes.
That definition originates in what law?
Rule 10b-5, the fraud law in the US in 1940s.
The assertion that the directors have a fiduciary obligation towards the shareholders was invented so as to fit insider trading into this doctrine.
No, so it's the other way around really. Fiduciary duty has been existing for 300 years now.
So, it's an old common law?
So, yes. So, fiduciary duty is common law. No, it's not.
Fair.
It came in the concept of Companies Act is pretty recent, I guess.
By that logic, if you're a director and you inadvertently chat with me about some information, I go trade on it, I make a profit.
Correct.
That's on insider trading.
That's not in the classical understanding of fraud. So, now that's the origin. Now, let us see how it diverges. It's completely diverged away from it to a case which happened just last week, SEBI case, in which they have essentially said that any kind of discussion, let us say we are friends, we are chatting with each other and you misuse this, you don't even misuse the information. It's become so strict that just the chatting itself has become an offense. So, I go home and tell my wife, oh, I have great M&A deal we have just finished. That's according to the new law an offense, but not an offense under the classical understanding of, because it does not fall into mens rea as absent, misrepresentation is absent, and the most important thing is there is no cause, there is no loss causation. Nobody is lost out because there is no transaction. So, in fact, 3 of the ingredients are missing. But India has chosen to move away from that. US has also moved somewhat away, but not so far away. But we have now moved into what is known as the possession theory in insider trading, which is essentially anybody who passes on information, whether it's senior, it doesn't have to be senior management, the sweeper of a company finds something torn in the dustbin, uses that offense. 2 directors talking in the back of a taxi, the taxi driver trades, again no intention to pass to anybody, but it's still an offense because it's a possession standard. Any information which comes out from inside of the company and somebody else gets it, and even without trading now it's an offense under the new brand new insider trading. So, that's kind of the broad overview. I'll just end by making 3 or 4 of maybe 4 or 4 soft points on in modern law, in modern regulations which we end up facing. The first is, just because unfair is does not make it fraudulent. And I always give the example of a person who is walking in a street and he finds a 100 rupee note, looks, nobody is around, nobody really owns that note. There is no way he could have found out who that note belongs to, picks it up and puts it in his pocket. Versus a person who steals, somebody is in a local subway, picks somebody's wallet. Okay. So, the person who has found the 100 rupee note has also done something unfair, but he has not committed a crime, because ideally you should have gone to the police station and deposited it there, saying this is not my money, I don't want to touch it, I found it. But it's not a crime, it's not an offense, and we forget this distinction when we look at particularly insider trading laws, not just fraud laws. And the example I gave you, which is just last week, sharing of information where you have not traded, there is no mens rea, there is no misrepresentation, there is no causation. Second quick point is on burden of proof. It's again, I mentioned in the beginning that burden of proof for fraud is much higher than, it's not a technical offense. So, which also means there is a presumption that you are not guilty, and that also has been short circuited now, because especially in insider trading, there is a deeming provision of insiders. So, and the range is so large in terms of your lawyers, your doctors, your accountants, just think of the relationship, and they are all deemed insiders. So, if I trade in a client's stock and I have really absolutely no price sensitive information of the client, I am presumed to have traded based on an inside information, and then I will have to rebut, which I cannot possibly, unless I put a GoPro camera on my head 24/7. How do I rebut the presumption that I had access to that information? Because there will be calls from me to the client, not on that topic. I am maybe giving an opinion on completely something else, but I will have to prove that I did not get that information out of the client. So, burden of proof is kind of the second soft issue. Third is interesting and a good development is the extraterritorial development, which is also very recent. The Supreme Court came out with the ruling essentially saying the securities laws of India will apply globally essentially. So, they can go after a person who was misusing GDRs, for instance, in London, and kind of trying to take the Indian markets through some convoluted scheme of having GDRs issued and then selling them in the market and changing the prices.
What about a simpler case? I am a non-resident, I am living in London, and I engage in insider trading. What is India's approach and position?
Insider trading in London markets on Indian stocks?
Indian security, I am trading on
definitely.
the LSE.
Definitely.
It's very much in my footprint.
Very much.
That's always been the case.
That's always.
What you're saying is the novel extraterritorial jurisdiction is about interpretation of GDR market abuse in London.
Correct.
As being pertinent as an FUTP crime in India.
Correct.
And that's the same for other countries also?
So, most countries have extraterritorial operations of the laws. So, again, if you start from the constitution itself, it says no law shall be deemed unconstitutional merely because it's extraterritorial, Article 246. So, US is the most kind of crazy. I mean, the FATCA, 15,000 crores of mutual fund monies are blocked. They are frozen because they don't have FATCA. Some poor guy in some village has not signed some form for FATCA. They are frozen as account. It's crazy. 15,000 crores, just mutual funds. And yeah, so the last bit is negotiated trades. Again, subject of you put it on your blog, a very good article on when self trades or circular trades, when you're on both the buy and the sell side, are not fraudulent, not manipulative. And there are lots of examples.
Chirag is one of the quotes.
Yes. Okay, so you're okay. I have, in fact, my book also covers this. I have devoted significant part of one chapter on these, and I can give you 2 or 3 examples when you're both buyer and seller of the same securities on the market, or it's a negotiated deal in which you negotiate with somebody. I'm the buyer, you're the seller. Let's figure this price out. First example is tax. Now, on exchange trades are subject to STT and therefore exempt from capital gains tax, and therefore it's completely legit to do a trade on exchange as opposed to doing it off exchange, where you'll have to pay 10 or 20% capital gains tax. Second example we've seen is where a broker wants to reduce the exposure. Let's say their terminals are frozen because they've reached their exposure limits. So they'll transfer particular shares of the same client to another kind of broking code. And negotiated trades, again, you Ranbaxy, actually the Ranbaxy deal was off market, but if they wanted to do it on market for tax reasons, they could certainly have done it on market, which is at completely different prices. So when market price was 350, they did the deal at 725. So you can, what they call, burn through the order book, and you can actually trade in the market. That would not be manipulative, even though it's at a price very different from today's market price.